Leading our bulletin this hour, former President Jacob Zuma has been disqualified from contesting the upcoming elections as a National Assembly candidate.
The Constitutional Court has clarified Section 47, subsection 1E of the Constitution as the IEC requested.
Now Zuma, however, remains the face of uMkhonto weSizwe party on the ballot paper.
There will be no unfinished business to complete for former President Jacob Zuma, as he is not eligible to occupy any seat in the National Assembly following the May 29 polls for at least 5 years after the completion of the 15-month sentence given to him in 2021.
This court concludes that Mr. Zuma was convicted of an offence and sentenced to more than 12 months imprisonment for the purposes of Section 47(1)(e) of the Constitution, and is accordingly not eligible to be a member of and not qualified to stand for election to the National Assembly until 5 years have elapsed since the completion of his sentence.
The court justices.
The Constitutional Court overturned the Electoral Court order which paved the way for Zuma to remain on the MK party candidate list, finding that the Specialist Court's reasoning was not sustainable. The Apex Court found that the Electoral Court erred in its interpretation of Section 47, subsection 1E, and clarified that the meaning of a criminal sentence does not depend on whether it can be appealed or not. A remission of sentence does not reduce the sentence, and it is irrelevant for the purposes of the said section. The ConCourt further found that the IEC Commissioner Janet Love's statement was ambiguous, and that the IEC acted within its powers in the Electoral Act when it determined the eligibility of Zuma.
The form for a candidate list is prescribed in Appendix 1 to the regulations concerning the submission of lists of candidates 2004. It requires that a party's list must include an undertaking from a party representative that, and I quote, each candidate on the list is qualified to stand for election in terms of Section 47 of the Constitution, close quotes. The court finds that in terms of these provisions of the Electoral Act, the Commission is empowered to determine before the election qualification for membership of the National Assembly.
The Apex Court further highlighted the purpose of Section 47, subsection 1E.
In respect of the merits, this court finds that the purpose of the disqualification in Section 47(1)(e) is aimed at maintaining the integrity of South Africa's democratic regime, which is founded on the rule of law, by ensuring that members of the National Assembly possess the requisite respect for the rule of law.
Zuma, however, will still appear on the ballot as the face of the MK party, as he is the registered leader, according to the IEC, which has welcomed finality on the matter. Canny Maphanga, SABC News, Johannesburg.
All right, let's stay with the story and speak to SABC News reporter Canny Maphanga, who's been tracking this particular story for us since court this morning. Canny, of course, a unanimous, judgment there, and especially when you look at the fact that the court finding that a remission of sentence does not necessarily retrospectively alter the sentence, and that was one of the heart of the arguments in this particular case. What else did the court have to say, particularly when you look at the issue of recusal?
Well, indeed, thank you, Bongiwe, and good afternoon to you and the viewers. Well, the Constitutional Court has essentially provided clarity on this very rare instance where you had a former president that was convicted and sentenced in a constitutional court, and by the design of South Africa's judiciary, that meant that that was the final decision and binding. But however, they've interpreted Section 47, subsection 1E within the text, stating that it does apply to the former president, and the implication of that is that he is not eligible for at least the 2024 general elections, that is the national and provincial elections, for standing as a candidate to serve in the National Assembly should they be successful at the polls. But it doesn't mean that it's the end of the road for him with the MK party. He still remains rather a face of the political party on the ballot, and he remains the registered leader of the political party according to the IEC. So when voters do go to that booth, they'll still see that ballot with the former president's face on it. However, he's not a candidate that can serve in the National Assembly. Remember, Section 47, subsection 1E is clear. If you are sentenced to 12 months or more without the option of a fine, that disqualification exists for at least 5 years until that sentence is completed. So we know that the sentence was handed in 2021 and the sentence imposed was 15 months. So we're looking at 2027 or 2028, where the former president can then be eligible to be a member of the National Assembly.
And it's quite interesting, especially when you look at the fact that a case also for recusal when you look at the justices themselves, but at the same time taking it further to the IEC's Janet Love as well, that she made pronouncements here and all of that, but the court saying that it was ambiguous and in fact it wasn't dealing with him specifically.
Well, the Constitutional Court goes through all the grounds that are discussed in the Electoral Court order. Of course, the counter application was brought by the former president when they headed to the Constitutional Court. They've made it clear that that recusal application was dismissed, making it clear that they're not excluded from determining this matter just because there were ConCourt justices that sat in the contempt ruling, and have also argued that that contempt ruling really doesn't form part of the determination of this matter. Then they've moved to the Electoral Court where it erred. Of course, they stated that the remission of sentence cannot be read in that manner. How you look at it is that through the separation of powers principle is that the executive decision has no bearing on the sentence imposed by the court. So this sentence imposed by the courts is 15 months, and that applies to the section. And then when it comes to Janet Love, they've agreed actually with the Electoral Court. You may remember the order of the Electoral Court was that they couldn't make a finding because there was no evidence before it to support the claims that there was a reasonable apprehension of bias. We saw that there were questions given to the parties to fully substantiate their claims against Janet Love and the IEC to defend them, and they found that indeed the context was ambiguous. And of course, they've clarified the very important purpose of Section 47, subsection 1E, to ensure that members of the National Assembly are those who can maintain the integrity of our democracy and ensure the rule of law.
And staying with Section 47, because one of the big contentions for the IEC was that is it their purview to then be able to implement this particular section, or does it rest with the National Assembly? And I suppose then it becomes clearer.
Yes, the Electoral Commission argued that it was within their rights to make that determination on eligibility, and the Constitutional Court has confirmed this by finding those powers in the Electoral Act. You may know that the Electoral Act determines how you submit those lists and gives you that disclaimer that you have to make regarding this issue of Section 47, subsection 1E, on whether someone has a conviction or not. So the intention is clear in the purpose, and it makes it clear in the Electoral Act that the IEC has those powers. And then, of course, the Constitutional Court ruling also vindicates the IEC, because on the back of these powers and them determining this issue, they had a concern about risking the election outcome and opening it up to electoral disputes and affecting the credibility of the elections 30 years into democracy. So that is why it was important, rather, to ensure that this matter was clarified and brought to finality before we go to those May 29 polls. It's not only an issue that would inform these current elections, but should we have a situation such as this that arises in the future, the correct interpretation of Section 47, subsection 1E is now clear, and it is binding by the Constitutional Court through the purpose of that legislation and who is qualified or disqualified from being a member of the National Assembly.
All right, Kenny, thank you so much for wrapping the day for us. That's my colleague there, Canny Maphanga, who's been tracking this particular story for us.